Imagine this. You're in a congressional hearing. A witness is getting grilled about releasing more than 66,000 criminal aliens.
And not just that, but the allegation that 9,500 were tied to terrorists. A huge public safety question right there.
Or picture an official facing questions about, say, the Flint water crisis and being accused of basically doing nothing for almost a year while people were exposed to lead.
Yeah.
Today, we're giving you that front row seat. We've gathered some really intense, sometimes jaw-dropping moments from government oversight hearings.
It's a unique look, isn't it?
It really is.
Yeah.
You get to see the inner workings and, yes, sometimes the big struggles within our government.
And our mission here in this deep dive is to, go beyond just the sound bites.
Right.
We want to pull out the key insights from these really high-stakes conversations. Help you understand not just what they said, but, okay, why does this actually matter?
What's the real impact?
Exactly. These moments, they're like little windows into how accountability works or sometimes how it hits a wall.
Absolutely. So we're going to unpack these moments, break down the debates, pull out the facts, sometimes surprising facts, and really get to the core issues. Okay, let's dive in. #1. Immigration, public safety, and deportation debates. So first up, a really, really heated exchange. It's about immigration enforcement, specifically deporting people classified as criminal aliens.
Yeah.
And the questioning starts with this incredibly direct, challenging question. Do you think that's terrorism if a woman's raped?
Wow. Yeah, that immediately sets the stage for a clash, doesn't it? It's about how policy gets interpreted on the ground.
So the witness tried to explain the criteria.
Right. They talked about eligibility for removal being tied to posing a threat to national security or border security or public safety. Standard procedure, you'd think?
But the questioner wasn't buying it, at least not completely.
Well, they pushed back hard, asking if a crime like rape always fits that threat assessment under the current directives. That was the sticking point.
And then came the numbers. I mean, these figures really hit hard.
They did.
The hearing brought out that more than 66,000 criminal aliens. So, non-citizens convicted of crimes were apparently let go, not deported.
Let go instead of removed, yes.
And even scarier, this figure that 9,500 were tied to terrorists, and the government supposedly admits they don't have a clue who they are.
I mean, if true, that's staggering. And it really highlights this discrepancy in policy application.
How so?
Well, on one hand, you have the official stance. Rape is priority number 2 for the Department of Homeland Security, clearly stated as a removable offense.
Okay, seems clear enough.
But then the questioning brought up this internal memo, and it seemed to suggest exceptions, saying deportation wasn't necessary unless there are factors indicating the alien is not a threat or should not therefore be an enforcement priority.
So loophole.
Potentially. There were even allegations mentioned about specific instructions, supposedly from Jay Johnson, the Homeland Security Secretary at the time, not to necessarily deport these people for crimes like rape or DUI or burglary.
Wait, so rape is priority 2, but a memo might say, make an exception, and maybe even verbal instructions not to deport. How does that square?
It doesn't, really.
Yeah.
And that's the core tension this exchange brings out, right? It's the gap between a stated policy, a legal mandate, and the discretion used in interpreting it.
It shows how one memo, maybe one instruction, could potentially undermine a whole category of enforcement.
Exactly. And it raises huge questions about clarity, consistency, and ultimately public safety.
Okay, shifting gears now from policy interpretation to, well, a really fundamental legal principle playing out.
The Fifth Amendment.
Exactly. The right against self-incrimination. We see a witness repeatedly asserting this right, and it led to some pretty pointed questioning.
Yeah, this is always fascinating. It's a bedrock of U.S. law, isn't it?
Yeah.
The right to refuse to answer if it might incriminate you criminally.
But the questioner here really challenged that blanket assertion. They argued, look, not all of your answers are going to subject you to incrimination.
Trying to narrow the scope.
Right, saying basically, you can only plead the Fifth if you reasonably believe the answer could be used against you in a criminal case or lead to evidence that could.
Makes sense.
And they even pointed out, you can waive your Fifth Amendment right. It's not absolute in all contexts.
But the witness held firm.
Completely. The response was like a broken record almost. On the advice of counsel, I invoke my Fifth Amendment privilege against self-incrimination and respectfully decline to answer your question. Over and over.
Sticking to the script provided by their lawyer, which
Yeah.
is, standard practice in these situations.
But what made it so striking were the examples the questioner used to kind of poke holes in this.
Oh, yeah. Like what?
Well, first, they brought up a TV interview the witness did previously. Apparently, he couldn't wait to come educate the members of Congress on drug pricing then. Very public, very vocal.
Contrasting past eagerness with present silence.
Exactly. Then his social media, apparently he was tweeting a whole lot, showing his life on that little webcam, again, very public.
So the argument being, if you're willing to share that much publicly.
Right. And then the kicker, this seemingly totally random question about buying an album. Something like Wong CL Han.
An album? That seems unrelated.
Totally. And that was the point, right? To suggest the witness was using the Fifth even for things that couldn't possibly be incriminating.
So this really gets into the weeds of the Fifth Amendment, especially for people in the public eye. Does the privilege cover everything, or just topics related to why you might be under investigation or indictment?
That's the question it raises.
And it highlights how your past public statements, your tweets, your interviews, they can potentially complicate things if you later try to claim a blanket privilege. Did you already waive your right on certain topics by talking about them freely before? It's a tricky legal area.
Okay, let's move to something incredibly serious. A public health disaster. The Flint water crisis.
A truly tragic situation.
This part of the hearing really zeroed in on the timeline, specifically the government's response time, or maybe the lack of timely response.
Right. The core accusation laid out was pretty stark. You had an EPA administrator who arrived on the scene, so to speak, in February.
Okay, so they were there early on?
Physically present, yes. But the allegation was that no effective action followed until January of the next year.
Nearly a year later, while people are drinking contaminated water?
That was the charge, an immense delay in a crisis involving lead exposure, which is, incredibly dangerous, especially for children.
And they brought in an outside expert, Mark Edwards.
Yes, from Virginia Tech. And his testimony, well, it pulled no punches. He's quoted saying things like, "We failed to get EPA to take lead and water risks seriously." Wow. And even more damning, he alleged that the EPA had effectively condoned cheating on the lead and copper rule monitoring since 2006, suggesting a systemic issue.
Cheating on safety monitoring.
That was the allegation. And he also slammed an op-ed written by the EPA administrator, saying it effectively absolved EPA of any wrongdoing or any role in creating the Flint disaster.
So, pointing fingers away from the agency.
That's how it was framed. And this all feeds into that larger theme of government responsibility, right? And what happens to public trust when the agencies designed to protect you are perceived as acting too slowly or maybe even covering up.
And there was a call for resignation.
Yes, explicitly, drawing a direct comparison to Susan Hedman, another EPA official who resigned earlier over Flint. It crystallizes that demand for accountability.
So the insight here is really about, what? Institutional failure.
It seems to point towards that, or at least the perception of it. How bureaucratic inertia, maybe a desire to avoid blame, can lead to disastrous delays in a real emergency. And that just shatters public confidence.
All right, next topic, Benghazi. Obviously a very high-profile, very politicized incident. We're looking at testimony from the congressional hearings.
Yes, and the testimony presented here tried to draw some very direct lines, connecting decisions to specific individuals.
Like what?
Well, linking Ambassador Stevens' interest in going to Benghazi directly to, quote, interests that Secretary Clinton had in Benghazi, suggesting it wasn't just his initiative. And then, a really crucial assertion, that the Benghazi facility was still open despite the fact it was below specs, meaning below security standards.
Because of Secretary Clinton.
That was the claim. And, critically, that she is the only one that can authorize waivers for SECA.
SECA being?
Standard Embassy Construction Authorization.
Yeah.
Basically, the rules for how secure a diplomatic post needs to be. The testimony stated only the secretary could approve exceptions to those rules.
So, pinning the decision to keep it open, despite risks, directly on her authority.
That's the connection being made, yes.
Yeah.
Placing responsibilities squarely at the top.
And then Cheryl Mills came up.
Right. Identified as counselor and chief of staff to the secretary. A key figure.
What was the point about her?
The testimony highlighted that she was copied on that email. An email, presumably, with information about the attack as it unfolded.
Yeah.
Which demonstrably undercuts Susan Rice's talking points.
The talking points used on the Sunday shows afterwards, suggesting it was a protest gone wrong?
Exactly. The email apparently contradicted that narrative early on. And Mills was also mentioned as being involved in preparing for later October testimony, linking her to the messaging strategy.
So this goes to the heart of transparency, doesn't it?
It really does. The questioning emphasized this idea that government needs to tell other countries the truth, and crucially, tell the truth to its own citizens.
And the argument was that not doing so had real consequences.
Yes. The specific claim was that the decision not to tell the truth on Sunday morning talk shows adversely impacted our ability to get to Benghazi, presumably hindering the investigation or response.
So the insight isn't just about politics, but potentially about operational impact, too.
Precisely. It suggests that discrepancies between what's known internally and what's said publicly can erode trust not just at home, but can also affect diplomatic relationships and the ability to act effectively on the world stage.
And as the questioner put it, pretty simply,
Yeah.
it always matters whether or not you can trust your government.
Fundamentally, yes.
Okay, this next topic is deeply unsettling. It touches on public safety and trust in a very direct way. It's about people with really concerning backgrounds ending up in public service roles, roles with authority.
Okay, yeah, that sounds worrying. What was the specific example?
The scenario painted was incredibly stark. Somebody comes with the authority of the EPA badge, and then they've got sirens or lights on their car, and they're a registered sex offender.
Wow. Yeah, that's chilling. Someone with official authority potentially entering homes or businesses with that kind of history.
Exactly. And the outrage in the hearing was just palpable. You could feel it.
I can imagine.
The questioner was essentially asking, how can there be a disconnect why people would be outraged if they showed up at your place of business or work, or some mom with their young child, and suddenly you're encountered this person?
It taps into a very basic expectation of safety, doesn't it? That people given government authority are properly vetted.
Absolutely. So what was the proposed fix, or the discussion around it?
Well, the conversation pointed towards needing changes at the Merit Systems Protection Board, the MSPB.
Okay, what's their role?
They're kind of like an independent watchdog for federal employment. They protect federal workers from unfair practices, political influence, that sort of thing, ensure the merit system works.
So the argument was the MSPB needed reform.
Yes. The testimony argued changes were needed there to better protect the American people and the taxpayers. And also, in the very blunt words used in the source material, to protect the employees that have to sit by this freak of a pervert.
Strong language.
Very. But it highlights the tension. The insight here is really about the difficulty in balancing employee protections, which the MSPB is designed to uphold, with the absolute necessity of protecting the public and other employees from individuals who pose a clear risk. Reforming these complex bureaucratic systems is a huge challenge.
All right, let's wrap up with a case study in, well, how not to roll out a major government project. The healthcare.gov website.
Ah, yes, the Affordable Care Act website launch. That definitely had some issues.
Understatement. The core debate highlighted here was about the launch date itself, October 1st.
Right.
The testimony claimed there was actually no law that required a go time on October the 1st. This directly contradicted what Secretary Sebelius, the head of HHS at the time, had apparently stated.
So the implication being they rushed it.
That was the argument, that they launched a substandard product just to hit this maybe arbitrary deadline instead of waiting until it actually worked properly.
Which led to all sorts of problems for users trying to sign up.
Exactly. Now, a key figure in these hearings was this expert, Mr. Park. He was brought in after the meltdown to fix things.
The cleanup crew.
Pretty much. And the questioner didn't hold back, praising him as like the smartest one in the room, even a savant.
High praise.
But then came the pointed questions. Where in the heck were you for the first 184 weeks? Basically, for the years leading up to the launch. And why didn't they bring you in to start it? Why didn't they bring you in to build it?
Good questions. What was his response? Well, he described his current role then as part of an all-hands-on-deck effort across the government, calling it a reclamation project.
Trying to salvage it.
Right. And he set this ambitious goal, to have the site functioning by the end of this month smoothly for the vast majority of Americans. A huge task, given where they started.
Was there any insight into why he wasn't there earlier?
There was an interesting reveal. Mr. Park was actually at HHS, the Department of Health and Human Services, when the Affordable Care Act passed. His expertise came out of the origins of Obamacare.
So he was there, just not on this project initially.
Apparently so. And that really underscores the key insight, doesn't it? The tremendous costs, financial costs, costing public frustration, cost and trust of not having the right expertise involved from day one on something this complex and critical.
A major lesson in project management for government, it seems.
You could definitely say that. Preparation and expertise matter immensely. Hashtag tag tag get tag outro.
Wow. Okay, what a journey through these hearings.
It really covered a lot of ground.
It did. We've seen that intense scrutiny on government actions, haven't we? The complex dance between policy and safety, the constant struggle for transparency.
And underlying it all, that critical issue of trust in our institutions.
Yeah. From those immigration debates and the Fifth Amendment clashes, to the painful failures in Flint, the questions around Benghazi, the disturbing issue of employee misconduct.
And finally, the healthcare.gov rollout saga.
Each one gave us this unfiltered glimpse, didn't it, into how government works, how it tries to hold itself accountable, and sometimes where it falls short.
Absolutely. And while these are specific moments, specific incidents, they really do light up these universal challenges in governing. Challenges that, aren't really left or right. They're just inherent difficulties in accountability.
Right.
And hopefully, for you listening, understanding these details helps cut through some of the noise. You get closer to what's actually happening behind the headlines.
It's definitely more than just sound bites, seeing the process, the arguments.
It's about the workings of the systems that impact all of us every day.
So here's something to think about as we close out this deep dive. How does hearing these detailed accounts, these specific exchanges from oversight hearings, change how you think about the way public policy gets made and carried out? And maybe more pointedly, based on what we've unpacked today, what specific areas of government accountability do you think need a brighter spotlight shown on them going forward? Something to mull over.